The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you decide how to protect yourself, your family, and your business regarding legal matters. It's information and resources that'll help you manage some issues yourself. If you do decide to retain professional counsel, you'll be better prepared, and so will the professional you select. Of course, either way, our goal is always to help you achieve the best possible results while saving time and money. Once again, and as always, we want to welcome and thank our legal counsel, Attorney David Bizarre.
Thank you, Dave.
From Bizarre and Associates Law Firm in East Providence, who continues to give us his legal information, insights, and anecdotes. So today, for the injured, the ill, those in peril, incapacitated, a caring bystander can actually make the difference between life and death. Thankfully, there are many Good Samaritans. Also, thankfully, there are many Good Samaritan laws that protect people who give reasonable assistance in time of need. The idea, of course, or the intention, is to protect people from being resistant or hesitant to perform some duties, lest they end up being sued or prosecuted for what might happen as an unfortunate consequence, wrongful death or whatever. So important to note that there are laws everywhere, but they vary state to state. So today we're going to cover what you need to know. Who is this covered by? Under what conditions? Who isn't covered? What happens when you are in a bad situation and there might have been a DNR in place? What happens if you are witnessing someone who's had a drug overdose? These various situations can become complicated. We're going to cover some of these as we go through the segment today. Also, it's important to know that you actually are a Good Samaritan if you call the police, offer a glass of water, or sometimes even a blanket. So thankfully, many of you, many more than are ever recognized, are Good Samaritans. So David, tell us about the Good Samaritan law such as you know it.
Okay, well, there are actually two sides to that coin. One is the Good Samaritan law that protects somebody from civil liability, from being sued, based on the assistance they render to somebody in need. So what that basically says is if you see someone in peril and you can render aid and do so safely for yourself, and you give them aid and it isn't perfect, and as a result they aren't saved or whatever, you're still shielded from liability as long as you didn't act wantonly, recklessly, or willfully negligent. So that is a shield. It's a shield to protect people who provide help in a situation where it's necessary. The other side of it is very few states at common law, this didn't even exist, is a statute that requires people to render aid when they see someone in peril as long as it's safe for them to do so. And there's only a handful of states, maybe 7 or 9 states, that require you to render aid or give notice to legal authority when you see somebody in danger.
Can you explain what is called the duty to rescue?
So that would be the other side of the coin, not the shield from civil liability, but the states that make it a criminal penalty not to render aid when you're able to do so. And I sort of call it the Seinfeld law, because the last episode of Seinfeld, the 4 main characters were arrested for not rendering aid to somebody who was being mugged. And at that point in time, I actually had never even heard of a law that required someone to intervene in some kind of action. At common law, that didn't exist. In Europe, there's laws that exist that require people to render aid, but in the United States, it's never until, these states that have issued these laws been a requirement to render aid. So Rhode Island has a law that says if you see someone in peril and you're able to render aid and you don't, you could be liable for what's called a petty or minor misdemeanor, a fine of up to $500 or 6 months in jail. Massachusetts has a reporting requirement that if you witness a violent crime or a serious crime, that you have a duty to report it to the police.
Good to know. So in general, it means everyone should want to try to render some help. I'm in marketing. You're a lawyer. Neither of us is in the medical profession. How is that impacted whether you are an EMT, not on duty, not the one who was called, but you just happen to be the bystander, as they refer to it, or if you happen to be a doctor who is the bystander. If they're not on duty, I understand there's some caveat that says there should be no expectation of pay. Okay, if you just jump in, how does that affect an EMT or a doctor if he's in that situation, or she?
Those are more difficult situations because a doctor is going to always be concerned that if I give medical services, even though it's an emergency and I'm not being paid, could I be held liable for malpractice?
Exactly.
And the question is, does the shield of the Good Samaritan law protect a doctor rendering aid, or is that doctor still going to be held to the standard of any reasonable doctor under the circumstances with the same training and expertise? And those that advocate for Good Samaritan laws and want people to render aid would argue that the doctor, the EMT, or anyone else rendering aid under those circumstances shouldn't be held to any different standard than any other Good Samaritan. But then there are those who would argue that, well, you're a doctor, you need to exercise your best judgment and give the best help that you can under the circumstances, and you could be liable. And I think it's going to be a state-by-state review of what the laws are and what's covered, and it's really why the laws are in place to not require, but encourage the requirements on the other side of those laws, people to render aid and be shielded from liability. That's why they're there, that's what they're supposed to be for, but doctors can still be hesitant, not wanting to put themselves in a position where they could be sued.
So if they are an EMT or a doctor in the state of Rhode Island, chances are they know the Rhode Island law. If they happen to be in Massachusetts, Connecticut, New Jersey, California, or up in an airplane for that matter, wouldn't you think that it would be a terrible thing for them to have to say, I think I can't render service? You know that they're not going to intentionally render harm or do something that would be known to be horrendous, but they might not be shielded, and it might keep them from acting at the call of duty or when something happens.
So I'm not going to give a doctor listening to this show a legal opinion on if you're
No, of course not.
If you're up in a plane and don't know what state you're over, whether or not you're protected. But I would say generally it would be my expectation that that you should render aid. You often hear this phrase, is there a doctor on board?
Yes.
Right? And we would want a doctor who's on board to come and render the best aid that somebody in need could get. And you would hope that no matter where they are or whatever state they're over or whether they're out at sea, that they're shielded from liability as long as they weren't wanton, reckless, or willfully negligent. So.
And when you speak to the other side of it, which is the duty to rescue, wouldn't you think that someone, especially if they were equipped with the knowledge and the skills and even a degree to help, that they should be, never mind wanting to help, but be compelled to help, that they should have that duty to rescue, they above the average person who lacks skills and training?
There is those 7 states or 9 states that have that requirement, and it has to be looked at with both. All right, now there's a statute that says I'm required to render aid if it's safe for me to do so, and also the other side of the coin. And if I do, and I don't act recklessly or negligently, willfully negligently, I'll be protected. So that would be the call to action. I think that would be enough protection and a requirement to compel somebody to give aid if they can.
Makes sense. I had read one scenario where in the state of Ohio, a woman saw an accident. She's a bystander. She rescues someone who was in a car accident, and she pulls him out of the car. Come to find out, she's an EMT. She pulled him out of the car. She ended up paralyzing the man. Guess what happens? There's a suit. First she is defended and she's cleared. Then there's appeal. Then she's not. Then she's now sued and she loses the second battle. The thought was, I guess in her defense, was I wasn't sure that that car was not going to blow up. Of course, I wasn't being willful, and I wasn't willfully trying to injure this person. I was effecting a prompt rescue, hoping, of course, that the car wouldn't blow up. But lesser of evils. It's a second judgment call. How can someone be sued for that? But obviously that's a rhetorical question. She was. And that outcome, I think, is an example of what you're talking about there. It's a dual-edged sword at times there.
Yeah, so I don't know the facts of the case, and I would hope that the facts are such that the way she did whatever it is she did was willfully negligent or reckless, because there's no reasonable ground to hold a Good Samaritan, even an EMT, liable if they're acting reasonably and rendering aid in a emergency situation where there's peril not only to the person who they're rendering the aid to, but in the way you describe it, to themselves.
Yes. Now, in view of this COVID world, you have a duty, the duty to rescue. In COVID world, if you sense that someone could be ill, you fear for yourself, you want to help, but you don't because there's that sword of Damocles of sort that you might end up with trouble yourself. Are you still compelled to help when in fact you could be in danger? Same thing if someone had blood that's exposed and you might be, and who knows what you might get. Is that part of the shield, David?
Well, the requirement says that you have to be able to do it without putting yourself at risk. So if you hold a reasonable belief that there's a risk to you and you're not willing to take that risk, then you're not going to be prosecuted for not rendering the aid. The prosecutions on those cases is very rare anyway, but,
Good to know.
But certainly if there's any possible risk to you that you're not willing to take, the law is not going to require you to take the risk to yourself to save someone else. For example, in that case with the EMT, if there was gasoline leaking and a concern that the car was going to blow up and that EMT took the risk, good for him or her. But if they didn't, it's actually not something I believe that would be prosecutable, because the law says you have to be able to do it without risking your own life.
Good point. So I'm not an EMT, I'm not a doctor, I did have first aid training. The first time I took it several years ago, I was taught what people are typically taught: CPR, mouth-to-mouth, and other things. Years later, I went back to recertify, especially for CPR. And while I did recertify, this time, and it was more recently, obviously, not, I would say, within the last 10 years, but I was told, even though you have these skills, you would be well advised to not do this unless, for example, you happen to have in your car something that we currently use now in COVID time, just in case you could be exposing yourself to whatever that person had.
Right.
I'm not sure that if I hadn't heard that, it would have ever crossed my mind at the time of, great peril or, an emergency, that I wouldn't just jump in anyway. I would like to think, even though I was cautioned that way, I would like to think that I would still do that anyway and pray that the person didn't have something that was transferable. But what an interesting scenario, and there are many, of course.
Today, obviously, it's something you would think about, probably from the outset, but back when you were taking the recertification class, the things that would come up for people was whether there was blood and the possibility of, back in the day, a concern about AIDS or things of that nature. And so you would want gloves and protect yourself from the transfer of fluids and blood and that type of thing. But again, because of the concerns that there are today, and because, as I said, there's not a lot of prosecution anyway, the duty to render aid is probably even lower today than it would have been before February because of those concerns. But the idea of the statute is to encourage people, and in some cases to compel people, to render aid in a circumstance where it's necessary. And there's a good reason to have those statutes, but there's also the need for common sense.
Good point. So does it not sound reasonable, whether it was an EMT, doctor, nurse, or someone, layperson such as ourselves, who jumped in to try to save someone, and you did, that's good news. Suppose they had DNR and then someone, do not resuscitate, and someone says the good news is you saved them, the bad news is that you weren't supposed to if such and such happened. Is that a prosecutable offense? How could you possibly have known? Well, maybe you could have known if you were the neighbor or something, but the chances of you knowing that under the circumstances, how could that be?
I would say unless there was a special relationship between you and the person where you should have known or did know, that there's not going to be liability for saving somebody in an emergency situation. And a lot of times, even people with DNRs in an emergency situation would want to be saved.
Good point.
It's, you know, when they're at the end of life and there's no hope for recovery and there's going to be a persistent vegetative state or something of that nature, don't keep me alive under those circumstances. But even folks that have these living wills or durable powers of attorney for health care or health care proxies, where they say, I don't want those life-saving measures used, they usually sort of have language in there that sort of clarifies the point that it's only if I'm at the end of life, I want to die with dignity. I don't want special things taken to save me when I'm not going to have any quality of life anyway.
So it might not have to be your decision at the point of that emergency. By the time you were rescued and taken to a hospital, then that might be a doctor's call if they found somewhere that there was a DNR, whether we're going to intubate or ventilate, whatever they're going to do. They get to make those decisions, but you, as the person on the scene at the time, wouldn't be held accountable, which seems reasonable.
That would be my argument.
What about, as we understand, there are so many, unfortunately, so many people who use and or abuse drugs. There is great concern among people who might have been the witness, they might have been living with and still been the witness, or they might have been the passerby, and they see that someone is OJ. They call. But now there's a concern that they shouldn't call because if they knew the person, lived with the person, associated with the person, that they too could be arrested, prosecuted, or whatever. That gets to be complicated, never mind at that moment, but more importantly, going forward. Care to shed some light on that?
Yeah, so many states have Good Samaritan laws for opiate overdoses or drug situations, and those statutes go even further than the Good Samaritan law about shielding you from civil liability. It also can shield you from criminal liability. So I think it was around 2016 or so, Rhode Island actually passed one of those types of laws. And the idea, the theory is we want to save a life. We don't want to prosecute somebody after they've gone through the process of helping save somebody's life. If, you know, the police or whoever, the law enforcement would say, hey, wait, how did you know they were doing it? Were you doing drugs? Did you have drugs on your possession when you brought them in? That type of thing. We want to encourage people to save a life.
So they can't ask at that time when you're calling, please save, I think somebody's in trouble. They can't ask you on the scene, they meaning police, once they arrive, what were you doing here exactly, and were you participating? Did you buy it, sell it, whatever? Can they not do that?
The Good Samaritan law is designed to protect against people who are saving somebody else's life, that particular Good Samaritan law. And so there's, in the statute, I want to call it immunity from prosecution or a shield from prosecution for criminal offenses based on what's going on there at that time.
I understand, too, as we pointed out at the top of the segment, that laws vary from state to state. I did check in Massachusetts. They, too, have posted that they want to continue to encourage someone who is witness to, regardless the relationship or lack of relationship, call the 911. You yourself will not be prosecuted at that time. So that sounds good, but the story unfortunately doesn't end there, because even if that person is saved, even if they're not saved, either way, that does not preclude the police officer on the scene having an occasion to rummage through your trash, in your drawer, whatever, I don't know, whatever else they might do, look around, see on your bedside there's maybe just a little bit too much there. In other words, maybe you've been participating in another activity such as dealing, measuring, dealing, whatever. And that means that while you might not be arrested then, it allows them to go back, get the search warrant, clamp down, and that person who was saved, as well as the witness, as well as everything. Now it ends up widening the net. So that in itself can be a deterrent, but what can you say to that? What do you say to that? You're still supposed to call, correct?
You're supposed to call. And in Rhode Island, like I said, there's no prosecution for something that you do when you're saving somebody's life, but if they observe things and they want to get a warrant down the road and come back, so once you save the person's life, maybe you want to stop participating in those activities yourself and clean up whatever might have been seen and go on with your life.
Sounds right. Hopefully you have the ability and the
to
times
do
and the
that.
wherewithal to do that. So let's talk about that Good Samaritan issue and the law that says you're supposed to take care of an individual. There's apparently an issue about you are under contract, you are a babysitter, you are a daycare worker, you are a parent. You're obliged to take care of whoever your charge is. If you don't, is that a Good Samaritan law or just a general violation of or gross negligence? How do they work with that? I mean, it makes sense that there may be some time when a babysitter fears for her own life, his own life, and leaves the scene of what could be a problem rather than take care of their ward. Sure, they should. How does that play out, David?
That's more common law, special relationship liability and requirement to act. So, for example, if you're at a daycare, I think you mentioned, and you have a child who is in peril, you don't have a duty to save that child because of the Good Samaritan law, the duty to provide aid. You have a duty based on your relationship with that child. And there is no shield from the Good Samaritan law on the other side for how you do it. If you act negligently because the child's been entrusted to you, there's going to be liability. So it's not really based on either one of the shield or the duty to act laws. It's really based on the relationship in that particular instance and many other instances like that.
So in some cases, if it's daycare, probably not a babysitter would have a contract, but a daycare certainly, they might have a signed contract. You must do this, then this, then this. A parent wouldn't, but you would think that any parent would throw themselves in front of a train or do anything, even risk their own life to save their child. So maybe there are some who don't. If they don't, is that parent prosecutable if he or she didn't?
There is a special relationship between a parent and a child,
Yes.
and there's a requirement that you raise your child in a manner that's safe. And that's when you have your DCYF cases and your criminal law cases and all of those types of things, depending on how severe it is, that there could be not only a criminal case against you, there could even be a civil case, perhaps.
Example, you're at a pier and you have a young child. You don't swim. That child, you turn your back 1/2 a second, children move quickly, over the side. You can't swim. You want to save your child. Hopefully you might find a life raft. Maybe you did, what's it called? Life ring. There isn't one. You can't jump in, no one's around, you shouldn't jump in. Are you liable because you didn't? You know you can't swim, you'd be taking the child down under with you. How does that work?
That's a really complicated situation. I don't know. I would just say that if I were there, whether I could swim or not, I don't know how deep the water is, whatever, I would want to do whatever I could do to save that child's life.
Including even run to try to get 911?
Yeah, find somebody, find
Yell,
something.
scream.
Find something that you know would float, take it in, and I'd jump in with something that floats and do whatever I could.
At what point does something like that cross over into being negligent? It's not willful, but it might be negligent. How do they decide? I mean, obviously some cases are very clear that someone was negligent was if you're driving a car at 90 miles an hour down the middle of a Manhattan Park Avenue or whatever, obviously that's gross negligence. You hurt someone. I don't care if you rescue them later, you're still going to be held liable. I'm sure that's prosecutable. And then there are those other layers of, is it tort law or something, because that was silly. But at what point under normal circumstances does someone get to say you were very negligent in how you handled that? How does that work?
What's gross negligence is what you're saying.
Yeah.
So let's go back to your example of the EMT who pulled the person out of the car. if the way they pulled the person out of the car is consistent with how any EMT would pull somebody out of a car, that's probably not negligence. If the person was stuck and they grabbed him by their neck, and dragged, and that's what rendered the person a quadriplegic or whatever you said they were, and that's not how you would take somebody out of a car, even if they're in danger, then that might be gross negligence.
So they do say to that point, David, that any EMT knows that you should not be trying to pull someone out because you're going to sever a spinal cord.
Right.
They're probably wrenched in some way that it would be almost impossible not to. Nevertheless, the other side is, well, I would rather try to effect a prompt rescue and hope that it didn't happen, but I don't want to see that car blow up either. Difficult.
Yeah, those are difficult circumstances, but you have to act in a reasonable manner to effect the rescue, and some things are just not reasonable.
At some point when it comes to a court case, you try your best and it seems like everything has worked out fine, the person's discharged, it's not a crime here, and then there's appeal. Someone like you was going to be called, David, I think we need to point out this or the other. Are those typical cases for personal injury when someone comes back and says that person should not have been exonerated, that EMT, for example, shouldn't have known? Do you hear those kinds of cases? Is that typical, or is that really out of, within the realm of extraordinary?
So the cases based on the Good Samaritan Law are infrequent. They're not something you see a lot. But there are other laws, too, that flow from that. For instance, if you get into an auto accident, you can't leave the scene.
Yes, tell us about that.
So there's a requirement to stay and render aid if someone, or call an emergency vehicle if someone's injured. And in fact, the level of criminality increases based on the injury to the person, if there's a person who was injured, or damage to property. So there's a requirement based on the driving laws, the motor vehicle laws, that say you have to stop at the scene of an accident, you have to give your information. If someone's injured and you leave the scene of an accident, it's a more serious crime. So you have all of those types of laws, too, that you have to consider.
So as I read, there's something that's actually called the duty to remain. So if you gave the Heimlich maneuver, whatever happened, they got rid of the food, the choking obstacle, you have to stay there until the EMTs or someone comes to rescue, or you still have something that's wrong, that's a prosecutable issue.
There could be liability or criminal activity for that.
Good to know. We covered quite a bit here. We hope that you are better prepared to handle any of these kinds of situations should you be called on to become a Good Samaritan. Thank you for tuning in to Law Matters. Please continue to do so. The law matters to you.